everyone. We're going to go ahead and get started. So welcome to the fourth day of Animal Law Weeks. Just to know from the outset, this event is being recorded, so if you have a question, please do wait for the mic. We'll bring it around to you. And then I just wanted to acknowledge our co-sponsors for this event, the Animal Law and Policy Program, the Animal Law Society, BALSA, ACLU, ACS, and SALSA. And so I'm very pleased to introduce our speaker, Astha Sharma Pokharel, who is a Bertha Justice Fellow at the Center for Constitutional Rights, where she works to defend the right to dissent and on issues around corporate accountability, Palestine solidarity, and abusive immigration practices. She is currently representing individuals in White Hat v. Landry, Bronner v. Duggan, and Awad v. Fordham. Prior to coming to the Center for Constitutional Rights, Astha was a Global Programs Fellow at NAMADI, an organization focusing on legal empowerment. Astha is a 2017 graduate of NYU School of Law, where she was a Root Tilden Kern Scholar, and where she was a student advocate in the Global Justice Clinic and in the Immigration Rights Clinic. So, without further ado, please join me in welcoming Astha.
Thank you. Thank you, everyone, for being here today, and thank you for everyone who organized this event. And thank you for getting us together. So today I'm going to be talking about the various ways in which the state and other powerful actors are trying to suppress progressive movements for social change. I'm going to talk for about 40 minutes, but please feel free to stop me or to ask questions or to make comments. And at the end, we're going to have 10 minutes or 15 minutes for question and answer. Don't feel like you have to ask me questions. You can make comments as well. Phrase your comments as comments if they're comments. So I'm going to start by talking about CCR. CCR started in the 1960s, defending the civil rights movement in the South. Our theory of change is based on the sort of uncontroversial proposition that transformative and lasting social change comes from movements led by those who are directly impacted by injustices. So this was true of the civil rights movement and historic movements for racial justice, and it's true today. So we work around issues of national security, immigration, justice in Palestine, environmental justice, criminal justice, racial justice, corporate accountability, so a range of issues, but our guiding star is really that we're movement-led. Can you guys hear me in the back? Okay. So my work is focused on environmental justice and justice in Palestine, but we're in solidarity with a whole bunch of other movements and take inspiration and learn from other movements as well. So I'll touch on a range of issues in my 40 minutes, and hopefully it's not too much information overload, but I want to present three takeaways. So I'm going to have to switch back and forth between my different slides, so just bear with me. So I'm going to sort of ground us in three key takeaways that I hope we can think about and stick with and really frame our discussion. So the first is that the movements that we care about are connected, including by the structures and the systems that are trying to suppress these movements, and also by the narratives that our adversary used to suppress these movements. So I'll talk about forces that are advocating for anti-protest laws like ALEC, law enforcement unions. I'll talk about the label of terrorist or extremist that's used to kind of delegitimize all of the movements that I'm going to be talking about. And I hope that these connections can help us think deeply about solidarity and about how to fight back. The second takeaway that I want us to sort of be grounded in is that laws and state legislation and state power that represses movements are really problematic because states are overbearing and hold a lot of power. But the ways in which our adversaries try to suppress us are also through private legal action. And this can often be extremely problematic. I'll talk about strategic lawsuits against public participation. And third, the third key takeaway that I want us to think about is that our role as lawyers and as advocates is to make the point that the harder they try to suppress us, the louder we become. So if you want to talk about suppressing a certain kind of speech through legislation or through slaps, we're going to win. We're going to defeat this in litigation, but we're also going to make the movements that we care about louder. So I'm going to begin by talking about ALEC. So ALEC, or the American Legal Exchange Council, is a 501c3, so a tax-exempt charity. And it was born as a political organizing network for those resisting the victories of the civil rights movement. And today, it brings together conservative legislatures and corporate lobbyists to develop and disseminate model legislation that sustains corporate power and white supremacy. So, according to ALEC itself, every year, its legislative members introduce over 1,000 bills to state legislatures based on the ALEC agenda, and a fifth of these bills actually become law. So ALEC is behind the ag-gag bills that I'll talk about that target animal rights activists. It's behind anti-BDS bills that target advocates for human rights in Palestine. It's behind critical infrastructure bills that target environmental justice advocates. And it's behind voter ID bills. The other thing that unites our movements is law enforcement interests. So law enforcement unions, for example, have backed some extremely repressive anti-protest laws. In Minneapolis, the police union there advanced laws specifically targeting the movement for Black lives. Police unions have also advocated for critical infrastructure laws that target environmental justice movements. And the other thing that unites our movements is the use of the label terrorist to delegitimize them. So I'll talk about the label of eco-terrorist that's used to target environmental justice advocates and animal rights activists, the label of terrorist that's used to target the movement, to legitimize the movement for Black lives, and similarly the label of terrorist that's used to delegitimize the movement for Palestinian rights. So a quick overview of what I'm going to talk about. I'm going to talk a little bit about law, so just ground us in some things that maybe we all know about, but just to make sure we're on the same page. Then I'm going to touch on animal rights and CCR's work that's mostly historic, but we do a lot of amicus support right now around supporting animal rights activism. And there's a lot there that's that we use to learn and to develop our current litigation and work defending other protesters in sort of other areas. Then I'm going to talk about environmental justice, specifically around critical infrastructure laws and some SLAPP suits, some environmental justice related SLAPP suits. Then I'm going to talk about Palestine advocacy around Palestine, anti-BDS laws and SLAPP suits, and then finally we'll touch on Black Lives Matter and talk about the anti-protest laws that have come out in response to the Black Lives Matter movement and a lawsuit against Black Lives Matter, the movement itself, and Black Lives Matter activists. So before I talk about specific cases, I want to quickly get on the same page on some law. And so some of us will be really familiar with this, but I just want to make sure that we have the foundation. I want to touch on Claiborne, which is a Supreme Court case that was really fundamental to First Amendment litigation and is really important to basically everything, all the First Amendment cases that we work on. And it's really important to understand it and how it safeguards the right to protest and the right to advocate for political and social change. So NAACP v. Claiborne Hardware is a Supreme Court case that came down in 1982. In the late 60s, residents of Port Gibson in Mississippi at an NAACP meeting organized a boycott of segregated stores in the town in response to intransigence related to several demands related to racial justice and racial equality, and also in response to intransigence to their demand that the police force of a town be dismissed after 2 police officers shot and killed a young Black man in that town. So the boycott consisted of what you'd expect: advocacy, education, picketing, and allegedly some acts of vandalism as well, although not allegedly by the defendants in that case. And eventually the white merchants sued the NAACP and individual defendants for a range of torts, including malicious interference with business relations. And the state courts in Mississippi found that defendants were liable for damages to those white merchants' business. So the Supreme Court overruled this decision, and there's sort of 3 kind of sets of holdings that are really important and that we use all the time. So the first is that boycotts and related activities are political speech, and they occupy the highest rung of the hierarchy of First Amendment values. So because of that, they can't be the basis of any liability. The second is that civil liability can't be imposed just because you're part of a group and some members of that group commit acts of violence. You have to show that the defendant has a specific intent to commit that act of violence. And then the third set is that there's 3 separate theories that might justify holding someone accountable for the acts of others. The first is if they authorized, directed, or ratified specific unlawful activity. The third is if their speech was likely to incite lawless action, and in fact did. And then the third is if the speech was a specific instruction. So that's kind of Claiborne and super important, and I'll keep referring back to it throughout. I'm also going to assume familiarity with how a court generally analyzes First Amendment challenges to a statute, but just kind of briefly, a court first decides whether the statute implicates protected speech, and if it does, then it decides what kind of scrutiny to apply. So if a statute is content-based, which I'll talk about in a second, it applies strict scrutiny, so the state has to prove that the statute is narrowly tailored to serve a compelling state interest, and otherwise it applies intermediate scrutiny. Okay, so that's the law. So the first area that I'm going to talk about is our work around, not only our work, just the general work around activism around animal rights. So like I said, I've not personally worked on these cases, but CCR has a history of supporting animal rights activists and currently does amicus support on some of these cases. And the history of how laws targeting animal rights activists were passed and how they continue to really successfully be defeated sets a precedent and a learning point for understanding the current wave of anti-protest legislation against other movements and how to fight back. So the first set of things I'm going to talk about is ag-gag laws. So the term ag-gag was coined in 2011 by a New York Times columnist to describe a series of state bills appearing across the country. And ag-gag laws include one or more of the following key elements. So the first is that ag-gag laws can prohibit documentation, so things like photography and video recording in animal enterprises and agricultural industries. They prohibit misrepresentation, so misrepresenting oneself in order to gain access to an animal agricultural facility. So for example, if you're asked, are you an animal rights activist? You say no, and then you go in, that's misrepresentation. And then the third is requiring the quick reporting of illegal animal cruelty to authorities, which sounds like a good thing, but it really makes it impossible for an investigator to compile enough information to show systematic and systemic abuse in an industry. So if you have to report an illegal activity as soon as you see it, that means you're outing yourself as an investigator. So there was a first wave of ag-gag laws in the 1990s, and the second wave started in 2010s, and it was really pushed by model legislation. It was pushed by the animal enterprise industry, the agricultural industry, and it was really also pushed by model legislation prepared by ALEC. So around 2006, ALEC drafted the Animal and Ecological Terrorism Act, which was model legislation that would make it a crime to enter an animal or research facility without consent and to take pictures. So this bill wouldn't only criminalize this activity, but it would also label it as terrorism. Since 2011, half of the states in the country have considered an ag-gag bill, though most bills haven't passed. And between 2011 and today, Iowa, Missouri, Utah, Idaho, Wyoming, North Carolina, Kansas, and Arkansas have enacted ag-gag laws, and I might be missing some. So CCR has a report that documents, a report from 2017, that documents how each ag-gag law in each state came to be. So I'm not going to go through the history of each, but most legislation followed a similar pattern. There would be an animal rights investigation, which uncovers evidence of illegal animal abuse, and this would be shared with the public, or legal animal abuse, and this would be shared with the public, and the industry would seek legislation to prevent future documentation. So there's obviously been a lot of resistance to these laws, and non-litigation campaigns have been successful. So in 2015, the Arizona governor vetoed an ag-gag bill because of public pressure. In 2013, a California ag-gag bill was withdrawn. In 2012, a Florida ag-gag language was taken out of a bill. And when the laws are passed, litigation against ag-gag laws is really successful. So the Idaho law was overturned in 2015, Utah's law in 2017, Wyoming's in 2018, Iowa's in 2019, and there was a second ag-gag law that there is currently in litigation right now, Kansas in 2020, and there's litigation ongoing in North Carolina as well. And so the challenges to ag-gag laws are largely based on the First Amendment, and there's also 14th Amendment, a 14th Amendment argument raised sometimes. So I'm just going to quickly go through the arguments that are generally put forward, and then talk about the Iowa case in particular. So these are the kinds of arguments that are presented in ag-gag litigation. So first is that laws that regulate only speech about the agricultural industry are not content neutral because they single out the agricultural industry for special protection. They're not viewpoint neutral either because they only burden speech that's critical of the agricultural industry. So if you only allow people to document what's going on in the agricultural industry once they get permission from the industry to enter, the animal enterprise industry to enter, it's naturally going to be only speech that's supportive of the industry. And these content and viewpoint based laws can't pass strict scrutiny because they're both over-inclusive and they're under-inclusive. So ag-gag laws are over-inclusive because they're not narrowly tailored for a specific, to serve a compelling state interest. So the interest of protecting property rights, for example, there's no reason to have an ag-gag law when you have sort of laws of general applicability like trespass laws, which already criminalize or make it a civil infraction to enter private property. And ag-gag laws are also under-inclusive because they only protect the property rights of certain industries without justifying the special protection. The First Amendment also guarantees freedom of press, and ag-gag laws really restrict the press's ability to report on the animal enterprise or agricultural industry. And ag-gag laws, the 14th Amendment argument that I was mentioning was that ag-gag laws run afoul of the Equal Protection Clause because many ag-gag laws are explicitly motivated by animus against animal rights activists, which is a politically unpopular group. So I'm not going to provide details on each ongoing challenge to state ag-gag laws. I'd recommend following Matthew Struger, who's an attorney who's worked with CCR and is really working on a lot of these cases. But I want to touch quickly on the Iowa case. So there in 2019, the district court decided that the Iowa ag-gag law that criminalized providing false information on an employment application with the intent to record images couldn't survive a First Amendment challenge. So the court there decided that this law was content-based because it would require the enforcer of the law to look at the content of the speech, the employment application, to see if there was false information. So since it's content-based, you then apply strict scrutiny, and the government there advanced two interests. The first was biosecurity, so people could be So their argument was that people could be vectors for like viruses and bacteria, and they could come in and infect the animals and then destroy the business. The court didn't buy this argument. The court was kind of like, what does misrepresentation on an application have anything to do with biosecurity? There's other ways to handle that. And then the second interest that the state tried to put forward was the protection of private property. And again, the court didn't buy that because the court said, well, there's other laws. There's trespass laws, for example. The court held that whether strict scrutiny or intermediate scrutiny was applied, the statute wouldn't satisfy either. So the state has now appealed this decision, and Iowa is now trying to pass a new ag law, and the second law has also been enjoined. So the next thing that I want to talk about is the Animal Enterprise Terrorism Act. And this is a federal law that was passed in 2006. And the ADA is violated anytime a person with the purpose of damaging or interfering with the operations of an animal enterprise intentionally damages or causes the loss of any real or personal property or places a person in reasonable fear of bodily injury or death. So you can see why this law is problematic. Under the language of the federal law, one could, for example, be involved in a campaign against a particular corporation's practices. The corporation's reputation could be damaged, there could be lost profits, and that person or campaign could potentially be held liable. And this actually happened. And so this would run afoul of Claiborne, which protects political speech even if it results in lost profits, and only allows liability in very narrow circumstances. And the other thing about this law is, again, it labels animal rights activists as terrorists, which is problematic. So CCR tried to challenge ADA in a number of instances. We lost in the First Circuit, for example, on a standing issue, which we can get into if folks are interested, because standing is often a problem in First Amendment pre-enforcement challenges. But then we got a useful ruling in the Seventh Circuit. We lost, but the holding was useful. So in the Seventh Circuit in US v. Johnson, we argued that ADA violates the First Amendment. We argued that it was overbroad. It protects a substantial amount of speech for the reasons that I mentioned, related to lost profits, et cetera, and it would clearly be overbroad. The government responded that that's not really what the statute is trying to do, that it's just causing, that it's only supposed to cover causing physical damage to tangible property. And the court agreed with the government. So the court ruled against us, said that the law wasn't unconstitutional, but interpreted the law to mean that it does not apply to causing intangible harm. And it means, so this means that causing an animal enterprise to lose profit and damage its reputation is not an ADA violation, which I think it's really important to say loud and clear, although this is just a Seventh Circuit ruling and the law is still out there. The court also upheld the label of terrorist. Okay, so the next area that I want to talk about is our work around environmental justice, environmental racism and environmental justice. And I want to talk about this by talking about the resistance to the Dakota Access Pipeline and the Bayou Bridge Pipeline and talking about Cancer Alley. So as many of you know, the Dakota Access Pipeline is a pipeline that brings crude oil from the Bakken region in the Dakotas to West Texas. So that's that pipeline right there. And then the Bayou Bridge Pipeline takes that crude oil into oil refineries in Cancer Alley. The resistance to the Dakota Access Pipeline has been led by Native communities out of concern for a damage to the environment, to native land, and to cultural heritage. And Cancer Alley, which is where the Bayou Bridge Pipeline ends up, is an area between New Orleans and Baton Rouge that's predominantly black and has an incredibly high density of petrochemical facilities and relatedly some of the highest rates of cancer. So you can see how the struggle against the Dakota Access Pipeline is related to the struggle against the Bayou Bridge Pipeline, is related to the struggle for environmental justice and against environmental racism in Cancer Alley. So I want to talk about the critical infrastructure laws that have been, next slide, that have been used to target, there we go, that have been used to target protests against oil pipelines. So as a result of the Dakota Access Pipeline protests, there was a national trend of legislation pursued by oil and gas interests and really pushed by ALEC and also law enforcement unions aimed at cracking down on and chilling protests against the fossil fuel industry. So you see these laws initially in Oklahoma and then in Texas, Louisiana, and elsewhere. So in Louisiana in 2018, the Louisiana Mid-Continental Oil and Gas Association drafted and proposed an amendment to Louisiana's critical infrastructure law, which made it a felony punishable by up to 5 years in prison to be on or upon the premises of a pipeline if forbidden to do so by an authorized person. So we're working with some folks, including individuals who've gotten arrested under this law, to bring a constitutional challenge to it. So the law is problematic in a number of ways. First, the definition of premises of a pipeline doesn't really require the premises to be enclosed or marked in any way. So under this law, you could be in a public park, in a sidewalk in Louisiana, which has all of those pipelines, and you could be considered to be on the premises of a pipeline. And of course, in a state, like Louisiana, it's all pipeline. So second, any authorized person is allowed to tell you to get off the premises of the pipeline for any reason not specified under the law. So we're challenging this law as being vague for the reasons that I just described, and we're also bringing First Amendment challenges to it. And we have a number of arguments, two of which I want to talk about. So first, we argue that the law is viewpoint discriminatory because it grants too much discretion to this unidentified, quote unquote, authorized person to decide when to use the law. So this is the unbridled discretion doctrine. where the idea is basically if a legislation is drafted in such a way that it gives too much authority to an entity to make viewpoint discriminatory determinations of when to silence speech or when not to, then it can be considered discriminatory. And we're also arguing that the purpose of the law was viewpoint discriminatory. So it was passed to silence protests against pipelines. And the legislative history there is clear with LaMoga and ALEC and the law initially in Oklahoma, which was passed against to respond to protests against the Dakota Access Pipeline. So the Louisiana government defendants have moved to dismiss the lawsuit. We've just finished, not just, maybe like 5 months ago, finished briefing on that in the district court, and we're waiting on a ruling. And this is one of the first challenges to the critical infrastructure laws that you see across the country, so stay tuned. So the other point that I had mentioned that I wanted to come back to was that in addition to legislation and other state efforts to silence dissent, we are also seeing civil lawsuits and other kinds of private legal threats or legal action to silence dissent. And we do a lot of work around strategic lawsuits against public participation or SLAPs, which are frivolous lawsuits that even though they're meritless can effectively chill public debate on specific issues. Defending against a SLAP suit is really resource heavy, requires a lot of time and money, and legal resources, and can be really burdensome, especially for a small nonprofit or an advocacy group or an activist. So I work with a coalition called the Protect the Protest Coalition, which is aimed at fighting back against SLAPs. The point of the coalition is to subvert the SLAP, to say, if you're going to file a SLAP, you're going to lose because we're going to win. And also, it's going to backfire because the more you try to silence us, the more attention you draw to us, and the louder we become. So really, the purpose is to make SLAP suits strategically ineffective. So we're representing Crystal Tubles, who is a Native American organizer who's involved in the protests against the Dakota Access Pipeline. She, along with Greenpeace and some other individual defendants, were sued in federal court by Energy Transfer Partners, the company behind the pipeline, accusing them of conspiracy, eco-terrorism, conspiracy to defraud the pipeline company. And they used RICO, which is a federal law, the Racketeering, Influenced, and Corrupt Organizations Act, which was passed to target mobsters, but has been used to target unions and environmental justice advocates. So it's a problem. The federal lawsuit was dismissed because the judge ruled that they'd failed to state a RICO claim. And now the company has refiled basically the same lawsuit in state court, alleging a range of property-related torts, for example, trespass, which ETP attempts to connect to Crystal because she was involved in a group, some members of which allegedly committed trespass. But as I mentioned earlier in Claiborne, this just isn't viable. You have to show some kind of specific intent, ratification, incitement, something like that, to be able to hold someone liable for the actions of a third party. So litigation on that is ongoing on the state case. The federal case has been dismissed, but it's a really big SLAP suit targeting a whole bunch of people, so stay tuned. So the next area that I want to talk about is Palestine. And I'm going to begin by talking about anti-boycott, divestment, and sanctions legislation, state legislation, and proposed federal legislation. So the movement for boycott, divestment, and sanctions against Israel is a movement initiated by Palestinian civil society aiming to sort of expose and challenge Israel's violation of international law and human rights abuse against Palestinians. The BDS movement takes inspiration from other historical movements, so the anti-apartheid movement in South Africa, the independence movement in India, and the boycott and divestment initiatives that have been crucial to the Black liberation movement, see Claiborne. And think back to Claiborne when the Supreme Court held that boycotts and related activities were protected under the First Amendment. So that's BDS, First Amendment protected activity. But beginning in 2015, ALEC introduced anti-boycott model legislation, and many of the state-level anti-boycott legislation that we see today has been sponsored by legislators affiliated with ALEC. ALEC is also involved in coordinating legislation that tries to conflate anti-Semitism with any kind of criticism of Israel, which is obviously problematic under the First Amendment for so many reasons. And I'm going to focus on the anti-BDS laws, which thus far have been enacted in 28 states, I think. And there are also a number of federal bills that have not passed targeting BDS. So anti-BDS bills are often nearly identical to one another and usually contain conditions on state contracts over funding or funding. So many of these laws require potential state contractors to basically sign a loyalty oath saying they'll never engage in boycotts. And there are also other laws that require state officials to compile a blacklist of boycott supporters. So a lot of these anti-BDS bills have been defeated before they become law. So in Virginia, Missouri, Massachusetts, they were defeated. And in New York and Maryland, they were defeated in the legislature, and then the governor had to adopt it because the legislature didn't. So when the laws have been passed, they've been taken to court, and again, have largely been successful based on Claiborne. So a federal court blocked Arizona from enforcing its anti-boycott law, finding that the law likely violates the First Amendment. A federal court also issued a preliminary injunction against Kansas's enforcement of the anti-boycott law. And the ACLU's case challenging the Arkansas anti-boycott law was dismissed, but plaintiffs are appealing this decision and are hopeful. So advocacy around justice in Palestine also is the recipient of a lot of slaps. And we've seen a lot of these and represent folks dealing with them have been for a really long time. So I'm not going to talk about these cases in great depth, but I just tell you to follow the Olympia Food Co-op case and the case against the American Studies Association, which are both lawsuits that were brought in response to the passage by each of these organizations of resolutions endorsing the call for BDS. And again, we've been successful in defeating both of these cases, though it takes effort and time. So against the case against the ASA was initially filed in federal court in DC, and the court dismissed the lawsuit, finding that the plaintiffs hadn't satisfied the $75,000 amount in controversy requirement, which you need to get into federal court on a diversity case. And now the plaintiffs have refiled basically the same lawsuit in state court. And the case against the Olympia Food Co-op was also dismissed by a lower court, and just last week, the Court of Appeals affirmed that dismissal. So that was a huge victory, a case that's around a decade long. And we've tried to use anti-SLAPP legislation to respond to these cases, and if people are interested in anti-SLAPP legislation, we can talk about that. But basically, this legislation allows a defendant in a SLAPP suit to file a special motion to dismiss that allows the court to kind of get rid of the lawsuit early on in the process, and sometimes get fees from the plaintiffs who filed the SLAPP suits as well. The other case that I'd urge you to follow, the other SLAPP that I'd urge you to follow is one that was filed in November of 2019 against the U.S. Campaign for Palestinian Rights, which is, an organization that many of us probably work with and partner with. And the lawsuit was based on an accusation of material support of terrorism for supporting BDS, for supporting the call to BDS, and for supporting the Great Return March in Gaza, which you all probably have heard about, is a march led by residents of Gaza trying to protect their human rights and right of return. So we'll be filing a motion to dismiss on that extremely attenuated and extremely far-fetched lawsuit on March 5th. So keep an eye out. So the next area that I want to talk about is the suppression of the Black Lives Matter movement. So I'm going to begin by talking about some of the anti-protest laws that have been passed against against the movement for Black Lives, and then talk about a specific case, Doe v. McKesson, which was just decided by the Fifth Circuit and is really problematic, and we should be keeping an eye out on and thinking about. So a number of laws have been proposed, and some have been passed in response to the in response to protests led by the movement for Black Lives. A lot of these protests, a lot of these demonstrations that many of us probably were also involved in, use the tactic of sort of going out on the street or onto a highway, which has been used historically as well. And some of these protests, the protesters have also used face covers to avoid retaliation. So several of these laws that have been passed since the Black Lives Matter movement started to gain attention target demonstrations on highways. So for example, a Georgia bill that was approved by the Senate but then defeated by the House in 2017 labeled as domestic terrorism anyone who disables or destroys a highway, street, or public building. And other similar laws stiffen penalties for obstructing traffic. And other laws criminalize covering one's face during protests, and these kinds of laws have existed for ages. And historically, challenges to these laws have been mixed. But of course, the threats of these kinds of laws changes in an age of surveillance. And we think a lot about the protests in Hong Kong right now. So the case that I wanted to touch on was the case against Black Lives Matter, hashtag Black Lives Matter, and DeRay McKesson. So in July of 2016, as you all probably remember, there was a series of Black Lives Matter protests in response to the police killing of Alton Sterling, and that's where that iconic photo of Aisha Evans facing down the line of police was taken, the one that we see all the time. So this demonstration was one of many across the country in response to police brutality and police killings. And the protesters in Baton Rouge went onto the highway, as many of these demonstrations did, and police responded in force, arresting about 70 people, including DeRay McKesson, who is a prominent Black Lives Matter activist. And allegedly around that time, some unidentified party threw something, maybe a rock, at this police officer. The arrested protesters eventually sued the city and the county law enforcement for excessive use of force and received a settlement totaling around $100,000. And separately, for having been hit by this object, the police officer tried to sue Black Lives Matter, hashtag Black Lives Matter, and DeRay McKesson, who the police officer alleged had organized the protests, led people onto the highway to obstruct it, and somehow should have foreseen that someone would throw a rock at or a hard object at a police officer. They didn't say that McKesson had anything to do with throwing the rock, and they didn't sue the rock thrower, or we don't know if it was a rock, it was a hard object. So the defendants filed a motion to dismiss, and Black Lives Matter and hashtag Black Lives Matter were dismissed from the lawsuit because you can't sue a hashtag and you can't sue a movement. And the claims against McKesson were also dismissed by the lower court. The police officer then appealed the dismissal to the Fifth Circuit, and the Fifth Circuit disagreed with the lower court on the dismissal of McKesson, although it agreed on the dismissal of Black Lives Matter and hashtag Black Lives Matter. The majority of the Fifth Circuit held that because McKesson had negligently organized this protest and led people onto a highway, he should have foreseen that there would be some violence and therefore should be liable for the violent actions of this rock thrower. So when this decision came down, we were pretty shocked. It was a huge departure from Claiborne and from major Supreme Court precedents, and it happened really quietly. There wasn't sort of like a big oral argument. There wasn't a request for supplemental briefing. It was just like some judge or some clerk decided that this is what they were going to do. And the dissent really disagreed with the majority. They argued that Claiborne really clearly answers this question because to be held liable for the violent acts of third parties, you need to satisfy certain conditions: ratification, authorization, direction, specific instructions, incitement, specific intent. Like all of these things you have to satisfy before you can hold someone liable for the actions of third parties just because they're all part of the same group. And the police officer had obviously not alleged that McKesson had done any of these things. So actually a few months later, after that decision came down, one of the judges in the majority seemed to have had a change of heart because this was a ridiculous ruling. And just a few months ago, that opinion was republished with that judge joining the dissent, which really rarely happens. But that didn't change the fact that the majority was still the majority and would have allowed the claim to proceed. So this case is coming down in the Fifth Circuit, and it's really, came down in the Fifth Circuit, and it's really concerning. But the ACLU has filed a cert petition to the Supreme Court, which we'll see what happens with that. And if it's not overturned, this is really a major blow to all the protections of Claiborne and to the protections that we really rely on under the First Amendment. So that's pretty much all I've got. And there should be another slide here, but it's the same slide that you guys saw earlier, so I'll just pull it up again. Yeah, so in conclusion, I just wanted to reiterate these three takeaways. The first, that the actors and the forces that are trying to silence us are all connected if they're not all the same. Think ALEC, think law enforcement groups, unions. Second, the tools that our adversaries use to suppress the movements that we care about include state power, include legislation, but they also include private action and legal threats, and those can be extremely crippling and silencing as well. And the third is that the reason that adversaries of these movements that we care about want to silence us is because transformative social change comes from movements, and they know that. And so our role as advocates is not, and lawyers is not only to win, to defeat these legislations and these lawsuits, but to really elevate the voices, to uplift the voices of those who they're trying to suppress. So if they're going to come after the movements that we care about, we're going to say there's an army standing behind the movement, waiting to defend and elevate what they have to say. Thank you.
And then we have some time for questions. If anyone has a question, please raise your hand and I'll get to you with the mic.
Just going to give an update on the ag stuff. So the Iowa first ag law was struck down in January of 2019. Iowa then passed the second ag law in March of 2019. That itself was also struck down as unconstitutional in December of last year. And now there's a third bill being floated there. And also Kansas was also struck down as unconstitutional just this last January, a couple months ago.
And I think the most recent Iowa law was just enjoined like last week or something, right? Yeah.
Thank you for your talk. I think I like the ability of you to weave together the different social movements and think of them as connected. I think it's great. My question is whether you think these efforts to attack protest or disable speech are solely the result of groups on the right. So if there's not a supervillain like ALEC behind one of these, what does CCR do, or what do you think about it? If for example, Planned Parenthood lobbied for laws that said there couldn't be investigations of reproductive facilities, there couldn't be misrepresentation, or there couldn't be documenting, do we find those similarly problematic? The use of RICO laws by the left, defamation suits from animal rights groups against objectors.
Yeah, I think it really depends. I mean, it depends on how you think about the way in which you want to be a lawyer or you want to be an advocate. One of the points that I was making was that it's not only our responsibility is not only to sort of uplift and promote laws like Claiborne and other kinds of laws that protect First Amendment rights, but it's also important to make these efforts really unsuccessful. It's important to elevate the underlying message and the underlying movement as well. And I think for an organization like CCR, we are not sort of willing to put the resources behind a group that is advocating for things, promoting actions or activities that would impact the movements that we really care about on the left. Someone like the ACLU and other sort of First Amendment, pure First Amendment organizations, I think would think about this differently and think about protecting First Amendment rights, pure First Amendment rights, as being really crucial. And in fact, in our briefing, we rely on some cases that protect the rights of the right to protest. And so we use it, but I think you have to have sort of a power analysis of like, if you are representing someone on the right, whose voices are you elevating, and what does that mean? And I don't have an answer to it. I think it's really complicated, but I think it's a really personal question.
We have time for a couple more questions if folks have any.
Kind of to follow up on that, in countries with less robust speech protections than the US, like, what other ways are there to defend? Like, what do you see, like, for example, maybe in Canada with the First Nations protests of pipelines that are going on right now? Like, what is another framework that doesn't rely on the First Amendment look like in doing this?
Yeah. Sometimes, I mean, when we think about of movements in other parts of the world that are facing repression, I like to think about the international human rights framework and the right to free speech and free association and all of these things. And I think it's really important to kind of cast a lot of these attempts to suppress movements as being connected transnationally and as being sort of similar efforts by similar kinds of structures, if not similar forces, to silence speech. And I find that helps both in kind of connecting movements across the world, but then also in kind of shedding light on how bad it is in one place. So the international human rights framework is one. I mean, the other is just organizing on the ground, sort of getting communities organized and mobilized to defend themselves and to defend other people that they're in solidarity with. The law is obviously not going to solve everything, or maybe anything, I don't know. And so much of the way in which we protect ourselves and our community is by organizing ourselves, right? So.
Yeah, so I'm curious if you see any acts of civil disobedience as just kind of so destructive to the social order that some sort of local community would be justified in enacting some restrictions on that type of protest. And then I guess another question, just to follow up on what was brought up before, I'm curious just theoretically if you sort of concede that you support a principle only really for its instrumental value in meeting the objectives of a prior political position that you already hold, how you can kind of expect that to convince people who don't hold the same political positions, which, presumably you're trying to kind of persuade people to support a principle for the principle's own sake. But if you're kind of conceding that you have to think about power structures, I mean, that to me almost kind of, you kind of show your hand about how it's really about the political position in the first place, so how you kind of navigate those two competing interests.
Can you remind me of the first question?
Yeah, if there are types of
civil disobedience
that you really see as kind of so destructive, even though they're not immediately violent.
I think in answer to your first question, so the question being, are there acts of civil disobedience that are so disruptive that there should be laws enacted to?
Or not should, but that a community could be.
Could, right. Yeah, I don't know. I mean, I think my inclination is to say no. We can think about it theoretically, but none of the examples that I've sort of worked on or thought about feel like they're deserving of any of the kind of legislative or other kind of attempts to silence them. To your second question, I mean, I think that's what I'm not saying that I don't agree that there's a sort of principled reason to defend First Amendment values. I mean, I think that there is that, and that's there, and I think there's a lot of organizations and actors doing it. I think that there's like enough people in the world that are willing to defend the principle. And I think that the only thing that I'm saying is that there's certain organizations and certain movements and certain people who are thinking about resource allocation and which are the voices that we want to elevate more. And I don't really see it as showing your hand and conceding that you don't care about the principle, because we do. It's just that we care about the principle when it applies to everybody, but we want to elevate the message of certain groups and certain movements only.
Thank you for your talk. I'm wondering if you talked about connecting movements, and given CCR has been working on defending dissent for a while, I'm wondering what have been the challenges that you've faced with connecting these movements that are often fighting, if not the same, similar forces. I imagine not all the movements are aligned.
Yeah.
Even among progressive movements, there's sort of people who will not be on board with Palestine, with Movement for Black Lives, as much as they would be with the other, maybe environmental racism, environmental justice. And how has that changed? How have the friction between these movements and the ability to connect them changed over time?
Yeah, that's a really good question. I mean, I think one of the struggles with connecting movements is that sort of talking about solidarity and sort of theorizing around solidarity can feel really contrived. Sometimes trying to connect two different movements that maybe don't really see the connection themselves, or don't really, like, the connections don't really resonate, can feel really weird and problematic, and you don't want to do it in a way in which it sort of dilutes the message of either movement or the experiences of either community. But I think increasingly you see the way in which these movements do connect. And I think to the person who left's question about what are the frameworks in which to understand how you can talk to maybe a movement that's less, I mean, Palestine is really difficult. It's really difficult to talk about justice in Palestine in other spaces. But I think it's, you think a lot about kind of language and how to sort of define what's happening there in Palestine, and how to define it as something that we're fighting against here as well. I mean, shouldn't we be able to criticize the actions of a state? Shouldn't we be able to talk about, shouldn't not only be able to, but shouldn't we really be criticizing the actions of a state that are engaging in international law and human rights violations? And shouldn't we really be upholding the rights of people everywhere, including Palestinians in Palestine and elsewhere? So I think there's a lot of frameworks that you can use to sort of connect the movements to show that they're not like, I mean, obviously each movement is really complex and complicated and deep, but there are certain threads that connect us all. And to be able to think about that kind of narrative and develop the language to talk about it in that way, I think is really important. And particularly in the Palestine space, I think has been really effective. Talking about BDS as a sort of historic strategy used for movements for racial justice and human rights movements has been effective.
That is all we have time for. Thank you all for coming in. Please join me in thanking our speaker, Astha, again.
Thank you, guys.